The use of AI today enables the collection and processing of data in volumes that would not have been imagined in the past. There is a two-way link between artificial intelligence on the one hand and big data and the Internet of Things on the other. In fact, the huge amount of data generated by interconnected devices and systems requires the use of algorithms that are able to extract value from that data. Moreover, it is just this enormous availability of data that makes algorithms increasingly reliable and intelligent. Clearly, a relationship like this presents some risks. In particular, there is the risk of such data, especially when they are qualified as personal data according to legislation, being exploited in an illegal or indiscriminate manner. For this reason, it is necessary to apply a legislation in order to regulate the processing of data carried out through such systems. The legislation of reference in this area is the GDPR, EU Regulation 2016-679, whose provisions, by virtue of the so-called principle of technological neutrality, must be applied regardless of the means and methods by which the processing of personal data is carried out. Therefore, also with respect to processing carried out through AI systems. With particular reference to the latter, we should focus on the so-called principles of privacy by design and privacy by default. Article 25 of the GDPR, in fact, establishes that the data controller, i.e. the developers and the operators of AI, must ensure by design and by default in its systems compliance with the provision of the processing of personal data. What does this exactly refer to? In this area, the most important profiles are the purposes of the processing, limitations to storage, and the principle of data minimization. With reference to purposes and storage, Article 5 of the GDPR expressly states that personal data shall be collected for specified, explicit and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. Moreover, they shall be kept for no longer than is necessary for the purposes for which the personal data are processed. The principle of minimization, on the other hand, requires that only data that are necessary in relation to the purposes for which they were collected should be processed. It is therefore not lawful for an AI system to collect and process data indiscriminately. However, the now widely available access to the IoT and its considerable capability to collect and process huge amounts of data could compromise compliance with these principles. From the point of view of minimization, in fact, the main problem concerns the capability of AI systems to carry out a selection of the collected data, in order to keep only those necessary for the performance of the service requested. A good solution to make the processing less invasive is identified in the pseudonymization and anonymization of the data. In this way, not only must the data collected by the AI systems be only that which is necessary for that type of processing, but if possible, it must be collected in such a way as not to permit the identification of the data subject. With regard to purpose and storage, on the other hand, it is not only necessary for the user to be really aware that it is giving its data for specific purposes of using the system, but also for the IoT to be able to process the data collected for the sole pursuit of those purposes. There is one last very important aspect we must underline. The GDPR is based on an anthropocentric vision of the relationship between human and machine, to avoid that there are prevarications of the machines on the humans, and to guarantee that the last word always belongs to the latter. For this reason, Article 22 of the GDPR prohibits so-called automated individual decision-making processes, establishing that the data subject shall have the right not to be subject to a decision based solely on an automated processing, which produces legal effects concerning him or her, or similarly significantly affect him or her. In other words, no artificial intelligence technology can be considered compliant with the GDPR without the data subject being guaranteed the right to obtain human intervention, to express their opinion, and to contest the automated decision. As it is evident, therefore, with respect to the processing of data by AI systems, we are not without regulatory protection. We can consider that the GDPR may represent a very adequate instrument to regulate the uncertainties in the processing of data by AI systems. However, due to the considerable complexity of the areas of life and the IoT tools that may be involved, the correct application of the principle seen will necessarily have to be carried out on a case-by-case basis, considering the peculiarities of each individual product that uses artificial intelligence techniques.